Hey guys, welcome back to Personal Injury Perspective. Today we're covering the tragic and senseless loss of Charlie Kirk. For this video, first and foremost, my heartfelt prayers go out to the Kirk family. The loss of Charlie Kirk has shaken our great nation to its core, and I truly hope that in the wake of this senseless tragedy that there somehow be positive change in our country. That's my prayer. And from a civil lawsuit view, this is one of those stories where the law meets a tragedy. And the loss is immense. The facts are despicable, but the legal road ahead on a civil case will be long and complex. Let's talk about it. Always remember, money will never replace a life in the civil court system, but money is the only thing the civil system offers as justice for cases like this. Charlie Kirk's shooter most likely will spend the rest of his life in prison, or he himself will be killed via the death penalty. That is the criminal side of the case. But people have asked me, is there a civil case here? Can you evaluate it? And that's what we're going to do here today. Let's talk about the facts that we know so far. Charlie Kirk was speaking at Utah Valley University, or UVU, in Orem, Utah, during his American Comeback Tour. This was an outdoor venue in a courtyard, amphitheater-style area. There were about 3,000 people attending this event. The event was coordinated with his private security team, according to media sources. Campus police, about 6 officers, were also present. According to reports, there were little or no security screenings, bag checks seemed minimal or absent, metal detectors were not used. The shooter fired from the rooftop of a campus building, specifically the Lucy Center for Student Success, a building with student advisement, administrative offices, etc. It is fewer than 200 yards from the stage or the location where Kirk spoke. The weapon was identified by law enforcement as a bolt-action rifle. Multiple sources say it's a .30-06 Mauser bolt-action rifle. The building's rooftop was reportedly easy to access, connected to another building by an elevated walkway and separated only by a railing. There was video taken by attendees showing what looks to be the shooter standing on the roof or running across the roof before the shot and after the shot. You can see that right here. There are reports of videos of Charlie Kirk saying that he and his family received threats regularly, death threats that is. I saw a YouTube video titled "Pastor Charlie Kirk Faced Death Threats," and he was never afraid of those death threats. I did not find as of now a verified source saying for this particular UVU event that there is a specific threat against him. What is not known yet publicly is the name of the private security company or detail hired by Charlie or Turning Point, whether the rooftop access was locked or secured, whether prior communication or intelligence suggested a rooftop sniper or any threat of that sort of a scenario, whether any special security planning was done for adjacent buildings or rooftop vantage points by his security team or the police. So as of today, there's a lot that we would want to know to really fully analyze the liability picture. But we have enough to consider the potential defendants in the case. From a civil perspective, the shooter, of course, is responsible. We see this all the time with shooting cases. The shooter is legally responsible for the act, but in practice, likely uncollectible. If the shooter lacks assets or insurance or the resources to pay a judgment, there wouldn't be any recovery for the plaintiff. You could sue him all day long, but there's not going to be recovery. If I had to bet, I would bet the shooter has very few, if any, assets or insurance to collect upon. Second defendant would be Utah Valley University, or UVU. As the host of this venue, UVU owes a duty of care to plan security, inspect the buildings, secure exposed vantage points. UVU is a government entity, though. It has sovereign immunity under the Utah law. Under the Governmental Immunity Act of Utah, 63 G7201, it says governmental entities and employees are immune from suit for injuries arising from the performance of governmental functions unless immunity is waived. Here are the waiver provisions. Under Utah Code 63 G7301, it includes a waiver for injuries caused by a negligent act or omission of an employee or by a defective, unsafe, or dangerous condition of a public building, structure, or other public improvement. So here, if the rooftop was unsecured, accessible via walkway, railing, or separating the building rooftop from another building, this may qualify as a dangerous condition triggering the waiver. Not sure. We have to look at that. Moreover, negligent security by the UVU campus in protecting Charlie could also be a negligent act or omission where UVU waived immunity. Defenses for UVU will include conclude that some elements of planning, such as security levels, screening of participants, and large event decisions are discretionary functions or policy level functions which remain immune. That is, your sovereign immunity tug of war. The government is permitted to make mistakes as it relates to planning level functions, but it waives immunity if it or its agents negligently carry out a task of that function. And this could be looked at as a task of that function, i.e. providing security. So let's move on to the private security and security detail. Again, it's been reported that Charlie and Turning Point USA had a private company for security. Because it reported that Kirk had a private security team, that entity, though it's unnamed publicly to date, could potentially be liable for failing to anticipate the risk, failing to secure vantage points, failing to perform adequate perimeter checks, perhaps failing to insist on screening or building checks. If they were aware, or they should have been aware, of death threats, that also raises the bar. They could be said to have noticed that there is a death threat, so more precautions may have been reasonably required. But again, we don't have any report that there was a death threat here before this event, but Charlie certainly had other death threats prior to this. Finally, some say Turning Point USA is a potential defendant. Turning Point USA was Kirk's employer and organization organizing this event. TPUSA might be seen as having some responsibility for security decisions or the event venue, but in Utah, workers' compensation immunity generally protects employers from tort liability for injuries suffered by employees in the course and scope of employment. And since Charlie Kirk was on the job, that doctrine likely applies. Also, TPUSA is never going to be sued by the Kirk's family. That's just not going to happen. Kirk founded the company. Regardless, TPUSA is an entity that one could point the finger at, arguing that it knew there was a threat, thus could have done more to prevent this tragedy. Thus, TPUSA in Utah could be what they call an empty chair defendant. Remember, in Utah, like most states in a civil case, fault can be allocated to any potential defendant even if they are not sued or remain immune, like Turning Point USA. They probably can't be sued, probably immune, but the defense would argue they're an empty chair. So let's talk about the law at play for cases like this, the important laws. A few laws really matter here. Utah has modified comparative negligence. Under the Utah Code 78B5818, if the plaintiff's fault is 50% or more, the plaintiff is barred from recovery. If it is less than 50%, the plaintiff may recover, but their damages are reduced by the percentage fault. The next big law is sovereign immunity. Again, we talked about this earlier. Governmental immunity in Utah has caps. Under Governmental Immunity Act 63G 7604, it caps the governmental negligence at $583,900 per person per occurrence. Let's talk about my thoughts on whether the Kirk family can recover in a civil case. Based on the available public information so far, based on the facts, I believe with proper discovery there could be a civil case against both UVU and the as yet to be named private security company. UVU's liability would hinge on whether it failed to secure rooftop access, whether security plans should have included rooftop and building surveillance, whether screening was reasonable under the circumstance, and whether they had noticed or should have noticed the threat or the risk. UVU would be in a better position than anyone to understand the access points and potential dangers on that campus. It's UVU's campus. The security company, if aware of threats, should have acted more aggressively, in my opinion. If it knew Charlie had death threats against them in the past, it should have been more vigilant in securing vantage points, requiring screening, inspecting buildings, making sure the rooftops couldn't be accessed, coordinating with the UVU police to check the building, etc. There are videos of kids who saw the shooter on the roof prior to the shooting. They're right here. It will certainly come up as to why those kids who are not looking for a threat could see one in their cameras, but not the UVU police or the hired private security company. That's going to come up. On the flip side, the defense is going to argue comparative fault, that Kirk had knowledge of threats and should have demanded more security, chosen a safer venue, i.e. some people are saying indoors, could have done indoors, not outdoors, insisted on more infrastructure checks, and UVU may try to argue their way out on immunity, the technicality, the planning level. An allocation of fault under Utah's comparative fault, if Kirk has less than 50% of the fault, the estate could recover in a civil case, but that's reduced by whatever percentage a jury feels Kirk was comparatively at fault. If 50% or more of the blame was put on Kirk by a jury, the claim would be barred. On this note, Turning Point USA could be an empty chair defendant. Even if not sued directly, in many jurisdictions, juries are asked to allocate fault among all possible responsible parties, including non-suited ones, for the purposes of reducing damage of the defendants in litigation. So this would definitely factor in if a case like this went to a jury trial. Finally, As noted, UVU as a governmental entity, and this means it gets damage caps. Under Utah Code 63G 7604, the maximum a plaintiff can sue for is $583,900. This seems like a strange cap number, but that's what it says. That is far below what many would see as just compensation for a wrongful death like this. On the other hand, the private security company may have liability insurance, general liability, or professional liability. In my experience, I have found that they usually do. A reasonable assumption might be $1 million in coverage or more, but there's no public record yet of the policy limits. We won't know that. If the total insurance coverage is only $1,583,900, or as discussed above, that's significantly less than the value of a life. If a civil action is brought, the Kirk family may find that civil damages, because of these damage caps, even in the best case scenario, falls short of what true justice would actually feel like in a case like this. And that's just how the civil system works. So let's look at the justice scale. I rate this case at a 5 out of 10 on the justice scale. Tragic loss. The legal obstacles are severe. So here's why. The cap on governmental liability makes UVU's exposure limited, even if they're fully liable. 2, proving knowledge or notice, securing vantage points, verifying security plan details will require detailed discovery, lots of back and forth. 3, comparative fault could reduce or eliminate recovery if the fact finder assigns enough fault to Kirk. 4, private security companies' coverage may not be enough to fully compensate what this loss truly is. And on a side note, because this is a high-profile case with strong media interest and political attention, there's a strong possibility that the defendants in this case may want to reach a settlement rather than face a prolonged trial and negative public scrutiny. That's a real factor here. Sometimes we find that even if the plaintiff has a complicated case where the defense is more complicated and the stakes are extreme, the defense will settle rather than fight. Certainly the political attention on this case will greatly complicate this case for the defense. Greatly complicated. This case is absolutely heartbreaking. It's shocking. But from a civil perspective, UVU and the private security company are the two realistic targets for liability in a civil action. This case shows us that sometimes the law gives avenues to seek accountability, but legal doctrines such as immunity, comparative fault, damage caps very often limit what is actually possible. The civil system will acknowledge a wrong, but may not deliver what feels like full justice. This has been Personal Injury Perspective. If you found this breakdown helpful, follow along as we continue to look at whether victims in high-profile cases like this can truly obtain justice. Be safe out there, and don't forget to like, subscribe, and comment. I will see you on the next episode of Personal Injury Perspective.